building civic engagement organization in the state of Louisiana, and for years now, we have fought for fair maps. Today, we are here as interveners in Louisiana versus Calais, standing shoulder to shoulder with black voters who now lead the charge to defend fair maps, and not only the state of Louisiana, but fair maps for all black voters in this country, and the future of the Voting Rights Act nationwide. The hope of achieving fair congressional maps has been Power Coalition's North Star. We understood very early on in our creation that if we wanted to build pathways to power for black voters, that it would start with census and then redistricting. From the state capitol to our nation's capital, our mission has been clear. We wanted fair maps that included 2 districts where black voters had a real opportunity to elect candidates of choice. For years, we have organized, we have legislated, and litigated towards this goal. We have kept our eyes on that prize through a delayed census because of COVID, a delayed census tally, multiple redistricting legislative sessions, district court hearings and a trial, 2 Fifth Circuit arguments, and now a second argument at the Supreme Court. We are exhausted, but we are undeterred. We know the stakes have grown. That's why you all are here, because this case has become not just about the state of Louisiana, but it has also become about this country and whether or not black and other voters of color will have a fair opportunity to have their voices represented. As we stand here today, we are looking at Section 2 of the Voting Rights Act and its future. It is one of our most critical checkpoints against racial discrimination in our voting process. The people of Louisiana deserve fair representation. We all do. The Voting Rights Act is our promise of equal citizenship, and I refuse to accept any future that demeans me and the people I love to a second-class citizenship. Because without voice, without representation, without the ability to elect a candidate of choice, we have to be really serious. Truly, it means that I am a second-class citizen if I cannot have representation in the halls of Congress, the halls of my state legislature, my local government, and in my school boards. And that's truly the enormity of what we are facing today. We have come too far to accept a future where my children will have less rights than their grandparents, where my vote could hold less weight than my neighbors, where the voices of thousands of black Louisianians are continually ignored. I've spent my whole career fighting for a multiracial democracy that I've never seen. But a multiracial democracy I do believe in. We know that it is possible. We are here to do the work to realize a multiracial democracy, and we ask that you join us in this fight. Thank you so much.
Good morning. My name is Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. I want you all to give Ashley Shelton another round of applause for her leadership and everybody from Louisiana. I stand before you as the head of the Lawyers Committee, but I also stand before you as a Louisiana native, as a native New Orleanian. Let me tell you something about our state. Our state is one that's a complex gumbo of culture, of politics, but also racism has been part of that mix. Racism has been part of that mix in voting and voting rights. As long as we've had elections in this country and in that state, there's been racial discrimination in voting, not just at the ballot box, but also in the drawing of maps. My very first depositions that I sat in on as a lawyer was almost 25 years ago in Louisiana because of unfair maps, racially gerrymandered maps. What I want to do this morning is disabuse you of a couple of myths. One myth is that this case and cases like it are all about partisanship, about the red and the blue, Democrats and Republicans. This case is about the black and the brown. This case is about the people whose voices, votes, and very vitality stand and hang in the balance. The people whose rights are going to be quashed, the people who won't have a meaningful opportunity to elect the candidate, who are told there were sideshows to democracy. This case is also not just about Louisiana. It's about nationwide. because we at the Lawyers Committee, our friends at the Legal Defense Fund and others litigate dozens of these cases every year using Section 2 of the Voting Rights Act. And the key question is this. The court has already found that there's been a violation of civil rights. In fact, the question is, can we correct that? Can we remedy that? Can we do anything about it through the courts? The other side is going to tell you that you have rights, but you have no remedy, that you only have rights. Your rights are words on paper. My friends, that is a short walk from what the Supreme Court told us in Dred Scott, that the Negro has no rights, which the white man is bound to respect. The question that our friends are calling today in this litigation and throughout this kind of cases is, will our rights be respected? Will our rights be honored? I'm so proud of our friends at LDF for litigating this case, to my sister friend Janae Nelson for arguing this case in the Supreme Court. And we're not here for show because we're on the dais. We are here to win for the people. Thank you.